Welcome to the Napa Legal Podcast. I'm Frank DeVito, Senior Counsel and Director of Content at Napa Legal.
I'm Kyle Nazareth, the Marketing and Content Manager at Napa Legal.
Thank you for joining us for another episode of the Napa Legal Podcast. So if you enjoy the content we're putting out, don't wait till the end. We appreciate it if you like the podcast. Subscribe to our channel on YouTube, Spotify, wherever you're listening from, and you can help support the work that we're doing so we can continue to do this show. So this week we have some fascinating cases, actually. We're going to start by covering a lawsuit in New York State related to the state's new assisted suicide mandate. Then we'll go to the Ninth Circuit and talk about a decision on another COVID vaccine mandate, religious exemption case. And we'll end with just a quick note on what I thought was a fascinating religious exemption request that was granted by a Unitarian woman asking for an exemption from using AI at work based on her religious principles. So I think a case of first impression there. But let's start in New York. This is definitely I would say the biggest case that we'll cover today. So we've covered the bill when it was pending signature before the governor a few months ago. But now that it's law, there's litigation around this assisted suicide mandate. So the New York governor, Kathy Hochul, signed a bill into law legalizing assisted suicide. It will go into effect in just a few weeks. And there are some exceptions that allow some organizations to opt out. There are both exemptions for certain types of organizations. They're not religious exemptions. And there are also opt-outs for religious groups who object, but only to some of the provisions. So it's a problematic law for religious hospitals and doctors. And the law essentially imposes that those who are covered, even those who get the opt-out from directly cooperating in assisted suicide, have to tell the patient about the option for suicide, their supposed right to kill themselves, help the patient find a provider that will. So basically there are referral mandates and information mandates that you cannot opt out of on religious grounds, which tees up this lawsuit. So first of all, it's just worth noting that New York's law is worse than I think most, if not all, of the other state euthanasia laws that we have in place currently. So both because New York is such an influential state, and now there's a lawsuit here, but also because the New York law is unique and particularly bad, it's worth covering this story in a little bit of depth. Excuse me. So first of all, the New York law compels healthcare providers to inform their patients about the supposed right that they have to assisted suicide. The waiting time between asking and getting it is problematic. The whole process of documentation of testing the patient is severely lacking. Again, just making it clear, assisted suicide is morally problematic and gravely wrong in general, but these kind of things that will basically allow people who might have, mental anguish over a diagnosis to have fewer safeguards in place so that they may be hastily, compulsively move on assisted suicide. It does make it even more of a dangerous bill or law. And further, one of the strange things, I think we've seen this in other states before, but it's very disturbing. If a patient is killed by assisted suicide under this bill in New York, the provider must sign a death certificate that states that the patient died from the underlying health condition, not from assisted suicide. So besides the fact that this essentially compels doctors to lie, it's also really problematic in gathering data on how many people are actually committing suicide by doctor. So because if the underlying cause of death on all these death certificates says cancer or what have you, rather than assisted suicide, it's very hard to track the numbers. And then there's also a provision in the law that states that healthcare providers cannot take any negative actions against any of its employees who act in accordance with the law, which you can see the problematic potential of lower level employees possibly pushing or doing things involving assisted suicide, and there being very little recourse that the employer or the hospital network can have to make sure the proper safeguards are in place. And so it's, again, besides the fact that this is just an objectively immoral and very disturbing act, the law has a lot of problems. So lawsuit was recently filed. July 17th, the complaint was filed. The plaintiffs are the Diocese of Rockville Centre, which is a Catholic diocese in New York on Long Island, and then several groups of religious sisters are also involved in the lawsuit. And the suit, obviously the relief sought is pretty straightforward. They're asking the court to bar enforcement of this law against religious organizations who object to assisted suicide. New York's law, as it stands, basically will compel Catholic doctors and healthcare providers to comply with this regime, if not directly by, assisting in suicide of patients, but at least of, having to convey information to tell patients they have this right, supposedly, to make referrals. It's it's very disturbing. So, sorry, I know I'm saying disturbing a lot, but it is that. So, a lot of initial commentary. Bishop Barris, who's the Bishop of Rockville Centre, New York, has come out very vocally against this. Besides being involved in the lawsuit, he made a statement saying he would never submit to the culture of death that New York is promoting. He called out Catholics to accompany the sick and the dying and not abandon them to death. Mark Rienzi, the president of Becket Fund and a board member here at Napa Legal, by the way, said that the New York law, quote, forces the sick and dying people to consider suicide at their lowest moment, right? Making them vulnerable to actions they otherwise may never have considered. That's one of the horrifying things about assisted suicide, right? Is by the time you change your mind, consider your other options, get into a better state of mind, it's too late. So the current law, the way it stands, makes it so the Catholics can't really do much to stop this, even though they morally can't prescribe suicide drugs or in any way cooperate with the assisted suicide regime for moral reasons. So forcing Catholics to participate in the culture of death this way, however indirectly, forces Catholics and other religious people, or even people who are philosophically opposed to this, to make the choice between either helping kill their patients or not participate in their medical practices. So a lot to say here. I'll try to contain myself to a couple of comments. So I want to make a cultural point, and then I'll talk a little bit about the law at play here. So I think it's worth noting that obviously this trend of legalizing assisted suicide, we've seen bills go through in several states over the past year, troubling, not entirely surprising, I would say, right? Intellectually, on a principled level, God's providence, right? The understanding that it's not our own will, but it's God's will that is the ultimate source of life and death. The idea that each person has an immortal soul, has immeasurable human dignity. The idea that God has a unique plan for every moment of every person's life, and we should not try to thwart that, especially by suicide. Those beliefs don't dominate our culture anymore, right? Once the dignity of man is no longer rooted in the reality that man is created in God's image, there's really no principle that'll hold that I can see to explain why abortion, infanticide, assisted suicide, and so on are intolerable in all circumstances in our society. And I think that that's maybe revealing of a larger problem, that there are many in the secular world who consider themselves humanists, right? They want human rights. They'll say things about the dignity of the human person. It's very hard to have humanism without Christianity, right? I think historically it's fairly clear that it has been Christianity that has been a force against inhumane practices, especially against the most weak and vulnerable, right? Everything from slavery to the exposure and killing of unwanted babies was quite common in non-Christian societies, and in some cases still is, right? Christians ended the slave trade in the West in the 19th century. It's a Christian movement. Christians rescued exposed babies in ancient Rome in the time of the early church. Christianity was instrumental to the end of so many barbaric practices involving, child labor, extreme mistreatment of women, and so on. It's very hard to try to pull Christianity out and still have human rights, human dignity, the things that we kind of take for granted. Anybody who's interested in kind of the cultural, philosophical underpinnings of this problem of humanism without Christianity, I'd encourage you to read. There was a really excellent article a couple of years ago at First Things called "We Are Repaganizing" by Louise Perry, and the image she uses is great. So it's important to remember the fallen world, right after the fall of Adam and Eve. It's like a dark, thick, tangled forest, right? Think of Mirkwood in The Lord of the Rings and The Hobbit, right? It's like it's tangled, it's dark, everything grows over so that it's frightening, right? There are evil things in the woods you can't really see in front of you. Poisonous things grow. It's a dark place. The world without Christ is a dark place. Christianity creates a clearing, right, where the light can come in, where you can have life and normality and beauty. But when you do away with Christian faith, that clearing doesn't hold, right? So I think that's kind of the predicament that like secular humanism is that they want to keep the clearing of human rights and human dignity and protection of the vulnerable, but it's Christianity that keeps the clearing clear. Without Christian faith, the forest regrows, darkness returns. I'm pretty convinced that these kind of pro-death, anti-human dignity trends in the world of assisted suicide and in other areas will just continue to abound unless and until there's a major revival of Christian faith in our country and in the West. So I don't know if there are secular arguments or legal arguments that are going to hold without a serious recommitment to Christianity. But as much as I could keep talking about that, I want to talk briefly about the legal issues at play here because it's very expansive. Becket's complaint is really good. It's over 100 pages. Anybody interested in this argument, I would actually read the whole thing. You can probably skip through the bulk of the sections that focus on each plaintiff and the work that they do, but the initial facts and the legal arguments are very good and worth following. So I want to point out a couple things. One, the focus here, there are a lot of First Amendment arguments, but the main focus is actually federal law. And I'll read from the complaint here. For close to 30 years, federal law has prohibited the use of federal healthcare funds to provide any healthcare item or service furnished for the purpose of causing or for the purpose of assisting in causing the death of any individual, such as by assisted suicide. That's the Assisted Suicide Funding Restriction Act from 1997. And then in the Affordable Care Act, that's Obamacare, it was made clear that any state that receives federal financial assistance, including Medicaid or Medicare funds, so that's everyone in the medical game, may not subject an individual or institutional healthcare entity to discrimination on the basis that the entity does not provide any healthcare item or service furnished for the purpose of causing or assisting in causing the death of any individual, such as by assisted suicide, euthanasia, or mercy killing, end quote. So in the law, as I said in New York, the exemptions are limited. It exempts religious doctors and networks in some instances that object to assisted suicide from direct participation, but as I said earlier, still mandates that they inform patients of their supposed right and provide referral information. So still indirect cooperation with a gravely immoral practice. This should also be barred by these federal laws as well as the First Amendment. So besides the federal law claims, there are a lot of good First Amendment arguments. I just want to highlight a couple very briefly. First of all, there's a church autonomy claim in the complaint, which I love to see this because it's important to not go right to free exercise. But basically what's argued here in the church autonomy count is that this assisted suicide bill impermissibly intrudes on these matters of internal church decision-making and governance, in this case by making it impossible for Bishop Barris and the religious sisters involved in the suit to operate according to and enforce the ethical and religious directives that are required for Catholic organizations in the medical field in America. So the church autonomy claim is strong. This is an internal question of doctrinal matters that is basically being sidelined by this law that says, no, it doesn't matter if you're religious, you have no choice. There's also a good free exercise claim, and they, I think, compellingly argue that, listen, this is not a generally applicable law because there are many secular exemptions for different health networks and doctors of, in certain kinds of practice of certain sizes. So once you have exemptions, we have some good precedent on that it's no longer a generally applicable law. So hopefully if that argument is persuasive to the court going forward, you have another attempt to kind of chip away at Smith and say strict scrutiny applies to this law when it's applied to religious organizations and doctors. One final note on the law, or not on the law, I guess I'll just back up a little bit. I think we've kind of hammered this point in different contexts on this podcast, so it's worth doing again here. There's another horrible example of unnecessary coercion, right? We've talked about it with the mandated gender pronouns in different cases, but here, listen, it's bad enough that the government has passed a law allowing doctors to, and requiring doctors to violate their Hippocratic oath, I think, the oath to do no harm, by making them or allowing them to kill their patients. Huge problem, obviously. But if that's the current regime that reigns in New York, people who want to commit suicide have no reason to go force a Catholic doctor or a Catholic hospital or nurse or what have you, who obviously object on moral grounds to this practice. There's no reason to force them to be involved. right? People know that this is a morally contentious thing that most Christians are against. They can go elsewhere, right? There are plenty of secular hospital networks. You can walk into those. There's no reason to force religious hospitals and religious doctors to be complicit with something that's gravely evil. When this is just coercion without any other purpose than saying this is where the regime stands and you must comply. It's a huge problem for religious liberty, and for religious practice in general. I mean, if things like this are allowed to hold and the exemptions aren't granted, either by statute or by court, it's going to be impossible for a lot of Catholic hospitals and doctors who do a lot of needed work in their communities to actually function in these states. One update that I got right before we hit record here, July 30th, that was this past Thursday, there was already an agreement reached between the parties not to enforce this law against the Diocese of Rockville Centre and the other plaintiffs pending the full court case. So not a full resolution, but there was a consent order that was agreed to, which is effectively a temporary restraining order until the case is decided on its merits. So, Kyle?
Yeah, I'd just like to think somewhat about the policy implications of laws like these because they're going to apply to more than just the exemption for the Diocese of Rockville, really. And we can see there was a good article by EPPC scholar Alexander Rakin kind of describing euthanasia laws and how they're being implemented in other countries or areas where they're already, widespread, like in Canada. And he describes a couple scenarios where there's a lonely Ontario widower in his 70s who gets euthanized because he had no meaningful relationships left, and a quadriplegic man who chose to be euthanized after a 95-hour wait in the ER because he had agonizing bed sores, and a hospital in Canada where they were kind of almost pressuring the patient's loved ones into euthanizing him because they saw that relieving that burden could be an act of love, apparently, right? So they're going to always target the disabled, the mentally ill, the physically vulnerable, right? Those people who society considers the weakest and most vulnerable, right? And it's going to always violate human dignity. Almost similar to the flip side of the coin being IVF, really, right? Where it's the creation of life through man-made choice, and life becomes commodified. Human beings are attached to the dollar price. Doctors or other people decide what lives are valuable and what aren't. So there's going to be a lot of line drawing according to human kind of decisions and faculties instead of God-given human dignity. And then, yeah, so just moving on into our second case then, this one's about the Ninth Circuit unanimously siding with an employee over her firing because of the refusal to go along with the vaccine mandate that the company had. So in 2021, the healthcare company Kaiser Permanente mandated that all employees receive the COVID-19 vaccine. And the employee was called Mimi West. She was a fully remote employee, which doesn't even make sense why she had to get the vaccine then. But she was a Christian Jew, or as I've researched a little more, they're also called Messianic Jews. And she requested a religious accommodation based on her religious belief that she couldn't alter her God-given immune system. And as support for that belief, she cited passages in the Bible like Deuteronomy 14:1, 1 Corinthians 6:19. And initially, Kaiser went along. They granted her the exemption. But after only a few weeks, the company started asking her a bunch of questions about, well, had she ever taken any other medications in the past? And why did her beliefs only prevent her from taking the COVID-19 vaccine? So Weiss restated her beliefs. She objected to the questions about her medical history because they're extremely broad, and they went past just the belief of, well, I can't alter my body in certain ways. And then Kaiser kind of refused to talk to her. They placed her on administrative leave without pay. Um, she tried to appeal it, they didn't listen, and then she was fired in January 2020 or 2022. So then she filed a lawsuit against Kaiser in 2023, and the district court ruled against her. They said that her answers to Kaiser, kind of answering their questions about her religious beliefs, were insufficient to notify Kaiser of the religious conflict between her beliefs and the company's policies about the COVID-19 vaccine. And it held that generic explanations in her initial request amounted to a blanket privilege that would create a limitless excuse for avoiding all unwanted obligations. So, of course, Becket steps in because they're a great law firm, and Weiss appeals the decision to the Ninth Circuit. And there, Kaiser's making an argument about lack of notice under a case called Heller versus EBB Auto. It's the second prong of the Heller kind of test. And their argument's mainly that Weiss failed to inform Kaiser of her belief and how it conflicted with the company policy. And the substance of their argument really was that Weiss had received other vaccines in the past, but she never explained why the COVID-19 vaccines she was saying she couldn't get are so different, and that her request established merely a basis to seek additional information, rather than informing Kaiser of a conflicting, sincerely held belief, and that her incomplete answers failed to give the company notice that she needed religious exemption. And so when I was reading this, it sounds highly suspect, honestly. Here, Kaiser's asserting that they're making a notice argument, but it's actually an argument saying, hey, for you to give proper notice, you have to explain to us why you think your religion allows you to get some vaccines, but not our COVID vaccine. That's not really an argument about notice, though. Notice that. It's an argument about the consistency of belief and whether her religion actually requires her not to get the COVID vaccine. So that's not notice at all. That's sincerity of belief. And luckily, on appeal, the Ninth Circuit judges recognized this, that Kaiser's argument was blurring the distinction between sincerity and notice. And they explained that the Heller case's notice requirement requires only enough information about the religious needs to permit the employer to understand that a conflict does exist at all. The employer doesn't necessarily have to understand the conflict or agree with the validity of the beliefs. And they go on to explain that Heller does not invite employers or courts to ask whether the employee's religious mandate or whether the employee's religion mandates adherence. The court warns that requiring that level of explanation would make employers like Kaiser essentially the arbiter of a religious doctrine. And then Kaiser will get to decide what doctrines a religion requires and whether an employee's belief fits that religious doctrine. So how it ended is the Ninth Circuit unanimously held that the notice Weiss gave to Kaiser was sufficient to notify them of her beliefs and that they conflicted with the vaccine mandate. And so in summary, basically TLDR, this was kind of Kaiser's attempt at an end run around sincerity disguised as a notice argument. And just a quick note on this, for people who disagree with the idea that a court's prima facie acceptance of sincerity of religious belief is a partisan kind of issue, or, it's just religious conservatives or something like that. Well, it's really not a political issue at all. Even Justice Ginsburg dissented in Hobby Lobby, but she said that there's an overriding interest in keeping the courts out of the business of evaluating the sincerity with which an asserted religious belief is held, and that in her view, this prevents courts from becoming arbiters of scriptural interpretation. So even Justice Ginsburg is on the side of, okay, we have to accept on its face the sincerity of this employee or specific plaintiff's religious belief. And we see this again in the Catholic Charities case, where the Supreme Court says courts can't tell a religion what it must do to be considered religious for an exemption purpose or a tax exempt purpose. So I think it's like kind of ironic or maybe somewhat hypocritical that these people who are very critical or scrutinizing on the sincerity of uh, a religious kind of objection. These are the same people who love to talk about separation of church and state. They love to say, well, keep your religion out of our schools or laws. There can't be any Ten Commandments in the schools. But then they'll also argue, on the other hand, that courts should decide sincerity. Governments and secular corporations get to meddle into religion and decide what religious doctrine is for religious employees. They get to decide what religions actually teach. So there's a double standard there, right? That to them, separation of church and state is a one-way street. They don't want religion to help guide the state morally at all or act as its conscience, but they do want the state to impose itself on religion and be able to tell religion, this is what you believe, and this is how an employee should be able to practice that religion. And this is what happens when they don't adhere to that.
Yeah, that's a great point. It's interesting, even if you go back to Jefferson's infamous letter to the Danbury Baptists, right, where that term wall of separation between church and state came from. If you actually read the whole letter, he's more concerned with having that wall up to keep government from interfering with religion than having religion be involved in the public square and in government. So always good to contextualize that claim about the supposed wall of church and of separation. But I wanted to note something you said that I thought was really important in the analysis, right? So the court was pretty explicit to say that a religious belief being asserted for an accommodation or an exemption, in this case for the vaccine requirement, need not be required by the religious authorities of that religion to justify an exemption. I think that's a really important point, and that was really important to Catholics during the COVID mandates. I was involved pro bono in helping a lot of friends and parishioners craft exemption letters. And so I was involved in this a lot. And it was difficult because the Pope Francis at the time and a lot of documentation about vaccines and public health from the Vatican over recent decades, they've shifted a little bit in emphasis, but it was always pretty clear that if vaccines are problematic in their development, right, especially when there are aborted fetal cell lines used in research and development, the teaching has always been that there's a prudential judgment, like the cooperation with the abortion is indirect enough that it's not always and everywhere immoral to use those vaccines. But the teaching until fairly recently was basically you should err on the side of avoiding those unless there's a compelling health reason. I'm paraphrasing here. And then in more recent guidance under Pope Francis and during like the COVID thing, it kind of flipped where it seems to say you err on the side of using these vaccines for the public health, but there was always a preservation that if your conscience doesn't allow you to use these treatments, that's a legitimate belief. But again, it was problematic because you'd have employers who were like, well, I saw that the Pope said that Catholics can get this vaccine, so what's your problem? Like this doesn't seem like a good religious exemption, but we're not bound by that. Certainly not in American law, especially because there are people who are members of like very loosely affiliated religions where there is no central teaching authority, and they still have the right to religious beliefs that warrant exemptions. So very important to insist on that you don't need unanimity from your religious authorities to justify a religious exemption in an individual case. One other thing I'll say is that I think it's important to note that for the purposes of good lawyering and for success in these cases, it is really important to think through the legal and religious issues at play. Because you're right, Kyle. Like in the courts really shouldn't be parsing out these claims and saying, "Oh, well, I don't know that your religion really teaches that," or that seems to be like not a bona fide. You get into some dicey territory there, but for the practical effect of having the best shot at getting the religious exemption on the ground. Like maybe you want to create good precedent and you just go broad, but like when I was helping people craft exemption request letters, at the time there were only I think 3 COVID vaccines available, and all of them were tainted with aborted fetal cell lines during the either research or development of the vaccines. And so I always strongly suggested to people to keep their objection to that because the church's teaching on not being cooperative, however indirectly, in abortion is pretty crystal clear. I think that's the strongest case at the time against a COVID vaccine mandate. And a lot of people really wanted to insist on, well, more like what she said, right? I have a religious view about, not altering my immune system or what have you. And some people wanted even more broad, like I have a religious right not to have the government tell me what to do with my body. I'm just like, you might really have that as a religious belief, but like employers were looking at that and saying, like, no, sorry, that's a political objection disguised as a religious objection. So it might be a legitimate religious argument, but I think this is just a pitch for good, careful lawyering and stopping and seeing, okay, this is going to be uphill. This is very politically contentious. What are the tightest ways that we can get the right result? Fortunately, here, it was a victory. But again, I'm always worried about the ability or the temptation of courts to dismiss religious objections as not in good faith or as, again, being more political than religious. And with that, speaking of religious exemptions, we're going to end with a brief examination that we came across this article the other day. And I thought it was so interesting. I'd never seen anything like this that we thought we'd highlight it before we wrap up. So, as you might imagine, many companies, especially in the tech sector, are mandating and tracking often their employees' use of AI in the workplace, right? AI is clearly opens up the ability to be a lot more efficient, to do things a lot more quickly. It's certainly a fraught endeavor. I have my concerns, but putting those aside, in the tech sector, this is just standard practice, right? AI is part of the work. There's a woman named Erin, I think it's Moss, Maus, was an employee at a tech firm, yet she applied for and received a religious exemption from the mandate to use AI because of her religious beliefs. Like I said, if not, it's not a court case, but a case of first impression, at least in my experience. So Miss Mouse is a Unitarian Universalist, and she claims that she has both environmental and ethical objections to the use of AI. I certainly share ethical objections. I assume the environmental are probably the amount of energy that AI data centers are burning. There's not much in the article I saw. But anyway, while AI is still new, it's being mandated very quickly, especially in the tech sector. And so this will, I think, raise a lot of questions to see how far this goes. I'll talk about that in a second. But it's interesting timing that this was just granted in the last couple of months when Pope Leo XIV just put out his first encyclical, Magnificat Humanitas, which outlined a lot of concerns about AI if it goes unchecked, undermining human dignity in a lot of places, including in work. And so, as most of our listeners, I'm sure, know, and as we've already covered even in this episode, federal law requires that employers consider employee objections for sincerely held religious beliefs, right? It seems like this is sincerely held religious belief. I don't know why else an employee would refuse to use AI. It seems sincere. So I don't have much to say, but I think it's an interesting, intellectual exercise to think through the practicability of something like this. Again, this never went to court because the employee was granted the religious exemption, but I think it's still worth looking at in general. On one hand, like I said, I have ethical concerns about AI use in professional work and what that can do to humanity and the dignity of work. This is certainly the first case I've seen of AI religious accommodation in the workplace. So while I agree with the ethical concerns, I'm kind of surprised given that, when someone requests a religious exemption, you can deny it if the burden is substantial enough. I'm kind of surprised that a tech entertainment company, like the employer in question here, doesn't find it a substantial burden to allow an employee not to use AI when working in that field. Again, I don't know her particular work or how AI heavy it is or how much slower or less productive she becomes without AI. But I think it raises a bigger question. At what point is it reasonable or unreasonable to request accommodations that actually strike at the heart of the type of work one's employer does, right? It's one thing for a worker in a bigger company to request Sundays or holy days off and they'll work on Saturday instead. If the organization has enough employees, this is usually pretty easy to accommodate. But it's different when the accommodation prevents a person from doing something that seems pretty central to the work. My assumption is that most tech companies are using a lot of AI. So to let an employee be exempt from using, I would think it's a substantial enough burden where they would maybe have grounds to reject the accommodation, even though it's a religious accommodation. So I don't think we'll get anything more from this case because they granted it, but it'll be interesting to see if this is a one-off. I can't really imagine a world in which tech companies are willing to exempt employees from using AI on any kind of a large scale. And I think they probably wouldn't have that hard of a time proving that the hardship that they would incur is sufficient enough to warrant denying the exemption. But we'll see if this is a trend or not. It was certainly odd enough, frankly, where I thought it was worth throwing out here. Kyle, do you have any parting thoughts on this?
Yeah, definitely. I think the employee in question too, she was specifically a coder, right? And what she was doing is reviewing code. So it seems like AI use increasingly is getting at the heart of what they do. So we'll see about the substantial hardship part of that. But The other thing I thought that was really interesting from the Business Insider article that we're reading from is it predicts a policy outcome from exemptions like this. And it says because of Magnifica Humanitas, released recently from the Vatican, that waves of Catholics are going to start asking for this exemption. And that's interesting because I think most, scholars at like Notre Dame or Catholic University reading Magnifica Humanitas come to the opposite conclusion, really, right? That for an exemption like this, where her kind of objection is, well, AI use is pretty much evil. Like Pope Leo directly states the opposite, that technology is not a hostile force to humanity in Magnifica Humanitas. And he does say that we should disarm AI, but that doesn't mean rejecting AI altogether. Um, he does say like technology is neutral, but the technology takes on the character of those who build, fund, regulate, and use it. So in practice, it's not actually a neutral thing. But what he's really calling for, rather than all-out ban of AI, is accountability at each stage of development and use of AI. So independent oversight, seeing whether legal frameworks that we create to regulate AI are moral, and the digital tools as well, they need to be looked over and regulated, he's kind of saying. And there are things that are genuinely off limits, he describes, right? The Pope describes, like AI-enabled warfare, right? Systems that kind of exploit workers and, reveal a lot of personal data, and even some of these wacky transhumanist projects, which see AI as the next step in human evolution so we can transcend our mortal coils, our bodies, right? Things like that are off limits. But the ordinary use of AI tools is definitely not in that category, and that's not what Magnifica Humanitas means. That the Business Insight article is kind of predicting a lot of Catholics will lean on to get all these exemptions. But on the other hand, I will say that's not completely impossible, right? I mean, just like we were talking about the COVID-19 vaccines, people have different interpretations of what the faith teaches, really, and will make legal arguments from there. And it's not for courts to necessarily look into the sincerity of those beliefs. So while I think it's really far from the majority of these exemptions that will be Catholics relying on Magnifica Humanitas, it's not impossible, I guess.
Yeah, that's a good point. I think it will often depend on the AI use too. I think just a general exemption asking to be exempted from using AI, again, I think that's probably a pretty serious hardship for an employer that's maybe not warranted. And I don't think we'd see a lot of that, but you could definitely see particular instances. I've definitely tried to get tech support on, the little chat windows that pop up on a website where they're like, no, I've asked it, or is this AI? Like, no, I'm a real person and it's obviously AI. So to the extent that you're programming AI to lie like that, that's a moral issue. To the extent that you're using AI to do work for a client and not disclosing it, that could be a moral issue. So I would expect more objections to particular AI uses rather than AI use in general, at least from my view of how Catholic teaching would apply to AI use in the workplace. All right. And with that, we thank you for joining us for another episode of the Napa Legal Podcast. So, as always, if you want to support our work, like, subscribe, help us out on our channels, like and subscribe on our social media platforms. That's all very helpful. And then also, if you want to know what we're up to, if you want to donate to our work, you can get all the updates on what we're doing and support us at www.napalegalinstitute.org. So we hope you'll join us next week as we continue to highlight and discuss the most important ongoing legal issues that affect religious liberty, and particularly the work of faith-based nonprofit organizations. We'll talk to you next week. Thank you for joining us, and God bless you.